My Lord, I adopt the submissions of Mr Hobson and also what's in the respondent skeleton argument, and I'll try not to be too repetitive of the latter. My clients are also an aircraft lessor, as your Lordships will have seen, and the detail of the leases, which I said I would say something about, I'll just very briefly outline. They've been stripped out of the bundle, so you have very little there, but essentially these are operating leases. So it's an aircraft that is supplied under the term of lease, usually 5 years or so, in which the airline assumes all risk of operation. At the end of the term, it's obliged to return the lease. So there's no sort of purchase option or anything like that. The nature of the leases is that there is a monthly payment of rent, and that rent is paid in advance of each month. There is a provision for a security deposit, and you do have examples of that in the lease. The security deposit is in the form of cash, a cash deposit, which the lessor is free to use as it chooses. But there is also an alternative to give a letter of credit. So the letter of credit is effectively a substitute for the cash deposit, and that's what happened in these cases.
So I assume that explains the date, because all the letters of credit are much later than the leases.
Yes, I think is a reasonable inference to draw. I think that's probably a fair inference to draw.
And how the cash deposit is a certain number of months rental, is it?
It varies. It typically is either a month or 2 months rent, depending on the credit risk. And there are also some deposits for maintenance reserves, which are effectively a maintenance sinking cost that is paid on account of.
So if one was analogizing it to sort of rent of a flat, there'd be it's a deposit to cover rent and any damage to the property on termination of the lease, if you like, or putting right any.
It's not so much on termination. It's more during the course of the lease. There's continuing maintenance obligations, and so the aircraft has to go in for, say, a shop visit, as it's called, which is to maintain the engine or the fuselage.
But the airline doesn't. The airline doesn't do that. That has to be done by the lessor.
No, the airline does that. Over the term of the lease, the airline does that. So the airline just gets the metal effectively, and then it has to register it in Russia, provide its own crew, and maintain the aircraft. And it is responsible for the maintenance of these aircraft.
Okay, but if the lessor is responsible for the maintenance of the aircraft, what element of the deposit, which is presumably with the lessor?
So the lessee is responsible for the maintenance of the aircraft.
Yeah.
But it pays. It is obliged. Under these leases, to pay what's known as a maintenance reserve, which is effectively a payment for its use of the aircraft that is then applied towards defined maintenance events. So, for instance, an engine requires quite a significant overhaul, and when the cost of that comes out, there will be a qualifying payment which the lessee can claim from the lessor from this maintenance reserve.
So it's security for the maintenance.
It's security for the maintenance of the aircraft. That's part of it. And the other part is security for other obligations on the lease, which can be called up. And your ladyship is right that is triggered by an event of default, typically, and there's a series of events that are described as an event of default. And these leases, I think some of them had what is effectively a sanctions clause, which is that there was a right to terminate if sanctions were imposed. And obviously, I think it's true of both claimants, but they were subject to the EU sanctions so far as the leasing was concerned. And that explains why 28th of March was a hard date for the leasing to end, so far as the EU position was concerned. The UK sanctions were not applicable to the leasing, because none of the parties, none of the lessors are UK citizens. My Lord,
thank you very much.
Just in terms of, just very briefly, in terms of the termination on constitution side, again, that was in the evidence below. Can I just hand up, it's a full copy of Sarah Redmond's statement.
you.
And it's just very briefly, paragraphs 18 on page 7 deal with the first aircraft and just describes effectively what happened following the invasion of Ukraine. And in relation to this aircraft, on the 28th of February and the 3rd of March, notice was given of these sanctions, that there were events of default, and as a direction that the airline ceased to operate the aircraft and relocate them outside of Russia. So that was the first step that was taken on those 2 dates. And then on the 4th of March, one seized of the same claimant, then terminated the leasing of that aircraft, given non-compliance. And so effectively, the airline's ability to use and exploit the aircraft contractually ceased on those dates. Certainly wasn't permitted to from the 28th of March, and the leasing itself was then terminated on the 4th of March. In relation to the second aircraft, that's over the page. And again, one sees at paragraph 20. Now, this aircraft was different because this aircraft was actually sitting in Sharjah in the United Arab Emirates undergoing maintenance. So it was out of Russia. And on the 28th of February 2022, notice was given the operation must cease, and again for the demand to be relocated outside of Russia. And then on the 25th of March was the termination. And the reference to it being in Sharjah is paragraph 22.
So one terminated on the 4th and one on the 25th.
Correct.
So presumably you'd say that from, at least from the date of termination, there was nothing that could be said to be an arrangement for the use of these these aircraft in Russia.
That's correct.
Because it was being done contrary to your instructions.
Contrary to the instructions, and prior to the termination and from the date of the different notices, there was also not a non-consensual use of the aircraft and or continuing presence in Russia.
Well, at least for a number of them, and one on any view was in Sharjah.
Yeah, it was already out of Russia, so it was no longer being supplied for use in Russia. Lord, I don't propose to cover the ground that Mr. Hobson covered, but just one point. Obviously, so far as Regulation 28 is concerned, the relevant provision of financial services or financial support, we would say, is the actual opening of the letter of credit and the confirmation given. That seems to me to be the relevant step of providing finance. The actual demand that's then made in due course is a different act and is not providing finance. That's simply performing an obligation that has already been assumed. That was a point that the judge had below, and we would invite your lordship to take that into account. My lord, can I then move on to US law? And I'm going to deal at a bit of a cant, if I may, with 3 issues. One is whether it's relevant. 2 is, if it is, what does it say? And 3 is if it applies where reasonable efforts made to obtain the license. I'll deal with it in that order. And I would echo the point that Lord Justice Snowden identified. This is a bit of a moot argument because it's not relevant to the UK position, and UniCredit has now paid all the amounts in either in US dollars or sterling that are owed under the letters of credit. So it's not as if the decision is being held up. And US law is not relevant to the Section 44 standard defence. So one does ask why the point is actually troubling your lordships on this appeal, but it is, so I'll deal with it. So far as relevance is concerned, we rely on 3 points, my lord and lady. First is that there was no payment obligation, did not require an act to be performed in the United States. The second is that even if payment could not be made in US dollars, it was always open to pay the respondents in sterling or euros. And the third is that any restriction under US law arose after the payment obligations fell due. My lord and lady, you're familiar with the Raleigh Brothers rule and what that says. It's a narrow exception where under an English law contract, the unlawfulness in a different country is generally speaking irrelevant. What one's looking at is the place of performance. Can I just very briefly show you the Banco San Juan decision of Mrs. Justice Cockrell, which I think is quite helpful. And that's in the second authorities bundle behind Spider 31, and that's at page 828. And in the law reports, it begins at page 812. Just very briefly, this was a case that concerned US sanctions imposed against Venezuela. So it's the Venezuelan petroleum company, PDVSA, which had been provided various credit facilities and failed to pay on them. The argument that was being run was that didn't dispute liability, but it was seeking to defer it till it had obtained a license from OFAC. And one sees in the head note just below H, just a citation of the Raleigh Brothers rule. It's Roman 2 on that. And then the paragraphs I'd invite the court to go to is paragraph 77, which is at page 828 of the bundle, or 606 of the judgment. And so the first point is paragraph 77 identifies the Raleigh Brothers as the limited exception to the general rule that an obligation under an English law contract is invalid and unenforceable or suspended in the case of a payment obligation so far as the contract requires performance in a place where it is unlawful under the law of the required place of performance. And then 78, there is again, if I could just invite the court to read that paragraph. It's probably quicker than mine trying to read it out. Can I also invite you to read 79 and 81? So, what's required then is performing party to act unlawfully in the required place of performance. Secondly, the rule is not engaged where one's talking about impracticability or impossibility. It has to be unlawful to perform. And third, the rule has no application where the party equips itself for performance by an illegal act in a third country. And those are all, we say, important. If one then looks at the facts of the present case and goes back to the letters of credit, and you were shown, I think, core bundle tab 19. And it starts at page 284 in the hard copy bundle. And so that's the confirmation that your lordships were shown, in which it was an undertaking to honour drawings under the aforementioned standby letter of credit with a cap of $3.6 million. And the proviso is that the documents are in strict conformity. And then over the page 285, one sees the standby letter of credit identified and said to be in connection with the lease of one aircraft. And it makes clear then at the bottom of 285 that it's independent of any of the obligations from the lease. And then on page 286, there's an authorization given to the beneficiary as lease manager of the aircraft to draw on UniCredit AG, and then sets out the amount and the requirement for a signed written demand, and sets out the format of that demand, which includes within it a transfer of US dollars to a bank to be inserted. And then if one goes to just where the second hole punch is, drawings under this standby letter of credit will be honoured upon receipt of such a demand certificate by mail, courier, service by hand. And the confirming bank will make payment to beneficiary's account specified in the demand certificate, valued after the close of business on in this case, fourth succeeding business day. And then gives an expiry. And one turns over the page at 287, and one sees just above the hole punch where it says, this standby letter of credit constitutes an obligation to make payment against strictly complying documents. So does the court see that?
Yes.
And so what we say is that the clear obligation being assumed is an obligation to make payment against a complying demand. And one then turns to the demand that was made, and that's at page, for this letter of credit in the next tab, page 301. And it then sets out in the language that's used and the instruction that's given to transfer the amount identified to a bank in London. So our submission is that it's an obligation to make payments to a bank account in London. And it's not an obligation that equates to performance in the United States, and it did not require performance in the United States. And we say that for a number of reasons. The first is that the place of performance is the place where the account is located. In this case, it was London. In some of the others, it's Dublin. And the obligation to pay money into a specified bank account is performed at the place where the bank is located. And that's supported by a decision of Justice Leggett in the Darling gas case. That's paragraph 80, and I'll give you the reference. It's Authorities 1, tab 26, page 706.
Just to be clear, is that an obligation to transfer or an obligation to make payment?
It's an obligation to make a payment. The transfer is the manner in which that obligation is satisfied, but the obligation itself is to make payment, and you get that from the letter of credit.
The obligation here is to transfer.
It is, because that's the form in which the demand
has to take place under the letter of credit. Yes, this is in the prescribed form.
Yes, but when
and it may be that this doesn't matter, but payment in all senses synonymous with transfer. I mean, obviously, if I come with clutching a carrier bag and with notes in it, I pay money into an account where the account is located, because that's how you think about it. If I transfer money, I think we saw in Justice Staunton's analysis, it's a slightly different thing that happens. My account with my bank, which may be somewhere completely different, is reduced, debited. Your account with your bank is credited. That's the nature of a transfer, in fact.
Yeah, I mean, I don't disagree that is the description of a transfer that is ordinarily understood. But I don't shy away from the fact that what the letter of credit says is that they will make a payment to the beneficiary's account. You go back to page 286. That's the obligation that has to be complied with. The demand is the trigger for that obligation. But even if one were to take your lordship's example, if one turns up with a bag of cash to be paid into another person's account, although that is physically a payment in, it is still a transfer of funds by the person arriving with the cash and depositing it into the account. And just to come back to my Lord Snowden's point, both page 286 and 287 both clearly say that the obligation being assumed is to make a payment. Now, of course, the demand is in a prescribed form, and that's higher up in this document as to the language that has to be used. But that's a language of effectively settlement and convenience. But the actual obligation, the hard-edged obligation here is to make the payment. And my Lord, I perhaps develop that last point. Your Lordship is right to have. My Lord,
Sorry, I don't think you completed giving us the reference to paragraph of Legate's.
Oh, sorry. It's Authorities 1, tab 26, page 706, at paragraph 80.
Thank you.
And there's a similar statement in the textbook Man and Proctor on the Law of Money, which is also in the bundle. So it's paragraph 1634. That's in the Authorities bundle, volume 2, tab 48, page 1383. And my Lord, can I just build on that last point when I was addressing my Lord Justice Snowden about transfer and payment and the difference between the two. And I think it is important that one maintains a distinction between the place of payment and then the place of settlement. And the transfer is the mechanism that has an underlying settlement in it if it is in the usual banking form. But that is different from the place of payment. And one sees that explained in the textbooks. So there's good on payment obligations, and perhaps we could go to that. That's in the Authorities bundle number 2, behind divider 49. At page 1391. Paragraph initial 5/46, internal page numbering 226. And your Lordship will see that there's a summary at the bottom of that page of the Libyan Arab Foreign Bank case. And then if one turns over to page 227 or 1392, it stresses that the decision demonstrates the importance of identifying the due place of payment, because as has been shown, the law place may have an impact on the enforceability of the bank's repayment obligation. This will, however, usually be the place where the account is held. In the Libyan Arab case, New York may be described as the place of settlement, but given the analysis adopted above, illegality in that place does not detract from the validity and enforcement of the bank's obligation to repay the deposit. London was a due place of payment. And there's a similar statement to paragraph 620, which is at page 1395. Internal numbering page 267.
Is that an accurate summary of what Mr. Justice Staunton decided? He decided, didn't he, that the bank won because they could demand payment in cash, which is a rather different point.
He did decide that, but I think it was also decided that the relevant obligation was performed in their account. That was the place of performance, was the payment into their account. I mean, that's implicit in the finding that they could pay in cash.
But if his decision was that London was the place of performance, not New York, he wouldn't have needed to think about payment in cash. He'd simply say, well, it's not illegal by the law of the place of performance, end of.
Well, I think he was then having to deal with the argument that was being made there, that New York was part of the place of performance, and he rejected that. I mean, it followed from his finding that that the performance could be effectively could be discharged by payment of cash. But I don't think it takes away from the underlying proposition that the place of payment where the account is located is where the performance is. And in that case, the steps that had to be taken in New York were preparatory to one means of performance. It wasn't the only means of performance. It might have been different if there had been some contractual requirement that was different. And again, one sees it at paragraph 620 and 621. This is the general rule that the debtor is to seek out the creditor, with the result that the place of payment will usually be the country in which the creditor is resident. And then 2 paragraphs down, this question may occasionally give rise to confusion, because as has been seen, a credit to a US dollar account maintained in London will generally involve a movement across correspondent accounts in New York. In such a case, however, London is the place of payment because it is the place in which the bank is required to credit the customer. It is the place in which the US dollar account is booked. English law therefore supplies the law of the place of performance. New York provides the place of settlement. It discounts the relevance of it being the place of settlement. Well, can I also just show you Man and Proctor at paragraph 7.43, and that's in the authorities, same bundle, previous tab 48. And that's paragraph 7.43. And again, that paragraph is dealing with the fallout from the Libyan Arab Bank case at 7.43. Sets out the facts there. And then at subparagraph B over the page, it explains that the English courts will not enforce a contract where the steps necessary to perform performance are illegal in the place of performance. It then explains why the rule didn't apply in that case. And that was London, where the depositor was entitled to receive his money. And the fact that funds would have had to clear through New York in order to achieve that payment did not mean that New York thereby became the place of payment. And then 744, if I could just invite your lordships and ladyship to read that paragraph. And I would stress that the passage that's in the sidelines, and that there is a distinction to be drawn between the obligation, the substance of the obligation, and the mode of performance. And also highlight that there is a single place of performance, which is both logical and sound. But Lord, moving on to my second point, which is that the transfer of US dollars rather than payment in cash would not necessarily have involved, or one shouldn't necessarily assume that it would be a transfer, would require any act taking place in the United States. It's not invariable that the US dollar funds transfer always has to involve a correspondent bank in New York. The Lordships, Lord Justice Snowden identified that even in the Libyan Arab Bank case, there was a reference to high proportion. There's an example given in paragraph 60 of Celestial's skeleton argument as to where, for instance, there could be a credit between accounts in London. And there's the comment that is made in the textbook of Gordon Smythe and Cornell which is in tab 50 of the same bundle of authorities, paragraph 11.54. That's page 1406, internal, of the bundle number, page 274, internal number. And this is a reference to OFAC guidance relating to Iran, that foreign financial institutions could process transactions denominated in US dollars that involve Iran, provided such transactions do not involve directly or indirectly the US financial system or a US person, and do not involve any sanctioned person. This indicates that OFAC considers it possible to process transactions in US dollars without involving US persons or the US financial system generally. That might technically be the case where a non-US correspondent bank processes a transaction on behalf of a non-designated Iranian entity without routing the transaction via the US.
But, I mean, this is a factual point for evidence, isn't it?
It is, but it's all it's seeking to demonstrate is that even if you go with it, stick to credit between banks, it doesn't necessarily have to go via the US. I accept the evidence in this case from Ms. Given was that one of practicality, but that's not the relevant test to engage the Raleigh Brothers rule. The third point, my lords and lady, is that payment in cash was also a possibility, and I rely on the analysis which the judge adopted, so that he was correct to find that as a possibility in the circumstances of this case. And I would submit that the fact that the demand itself doesn't request payment in cash doesn't alter that analysis. Because if payment could not lawfully be made in the funds by transfer, then we would submit that UniCredit was required to pay in cash. Whilst I accept that the demand contemplated a payment by funds transfer, as I've already submitted, UniCredit's obligation was to make the payment into the account. And we would say that the judge was correct at paragraph 175 to distinguish between of his judgment, and that's page 239 of the core bundle, to distinguish between the fact that a demand was a trigger of an obligation to pay, it crystallizes the obligation to pay, and the manner in which that obligation was to be fulfilled. And so effectively what the demand does is to trigger liability. So UniCredit has to make the payment promised. The mode of performance contemplated as funds transfer, but that's not the only way in which the payment obligation could be satisfied.
Sorry, just to quickly interrupt. I'm not sure it makes any difference, but you said it would be, you maintain it would be possible to pay in cash, then I think you said cash into the account specified, so
well,
they're not the same thing.
No, I mean, I think, I don't think it matters.
It might matter because obviously the demand on its terms refers to an account.
Well, it could be done by paying cash into that account in the London branch. That's just the mechanics of how the cash is to be credited. But it's not essential that it's paid into that account.
Thank you.
There is also
what you can find an account somewhere else and pay the cash into. You're saying that the obligation could be satisfied if an account could be found elsewhere and payment made to that unilaterally.
That would satisfy the payment obligation, but there's no reason why they couldn't pay to the JP Morgan account that is by an alternative means that has been identified in the demand. My Lord, there is also in the celestial skeleton argument a reference to the Brimley's case for authority for the proposition that an instruction to pay encompasses within it the tendering of the commercial equivalent of cash. And I'll just give you the reference to that. That's at Authorities 1, tab 15, page 374. Now, so far as UniCredit raise an argument about the practicality of a payment in cash, namely where they say it presents practical and unspecified anti-money laundering issues, that's not a valid reason to bring it within the Raleigh Brothers exception. There's, as I showed you, court, it's illegality as opposed to impracticality. And what Ms. Given's statement at paragraph 85 in the bundle references the supplementary bundle, tab 2, page 45. It refers to payments being routinely cleared in the absence of a practicable alternative. What she doesn't say is it's not possible to do so by making payment outside of the United States. And we accept that payment of a significant sum of cash is unusual. But as a last resort, if payment by other means is not possible, then there's no good reason why it shouldn't be required in cash. If that was the only way to pay and discharge the obligation assumed. My Lord, the next point is that if US dollars was not possible and as an alternative to cash, it was always open to UniCredit to pay in an alternative currency. And we say that they could have paid the respondents either in sterling for the UK account or euro for the Dublin account. And that relies on the rule under English law, where the sum in a foreign currency is payable in England under a contract governed by English law. The debtor has a choice to tender payment in a foreign currency or sterling. And the rule for that is set out in Dicey and Morris. And that's in the...
That's a rule about if payment is payable in England.
Correct.
It doesn't say anything about Ireland.
No, I was going to show you a passage about how Dicey treats that and then what the evidence is in this case on that.
Okay.
So that's at Authorities to tab 46 at page 1359. And it's subrule, so if we start at 37R050, subrule 2 sets out the basic rule that if a sum of money expressed in a foreign currency is payable in England, it may be paid either in units of the money of account or in sterling at the rate of exchange at which the units of the foreign legal tender can, on the day when the money is paid, be bought in London in the recognised accessible market. Query whether this rate of exchange also applies if English law is not the law applicable to the court. We don't have to worry about that. And then the rule is then explained at paragraph 37053. And again, if I could just invite the court to read the sideline bit of that paragraph. And then one then has paragraph 37055, which is dealing with the point that my Lord Justice Mayles just raised, which is that it's the lex loci solutionis that should govern the question of what currency a debt can and must be discharged if it's due under an English contract but payable abroad. On the other hand, English law should, in this case, determine the proper rate for converting the money of account into the money of payment. If a debt expressed in whatever currency, pounds, is governed by English law and payable in Switzerland, for example, Swiss law should determine whether it can be discharged by tendering Swiss francs. So you apply the law of the place of payment, and here the position in Ireland is treated as the same as that in England. We have that in the, or at least is accepted in this case, as being treated as the same in England. And that's a letter from RPC dated the 9th of November 2022. That's the supplementary bundle, tab 40, page 220. Perhaps I'll just show that to the court. This was a letter that was generated in relation to amendments to the particulars of claim. It's paragraph 2, page 220. So the parties have agreed to proceed on the basis it's the same as English law. And obviously that proposition had support from Libyan Arab Bank and the references at pages 764, in the authorities bundle, page tab 20, page 589 through to 591, which again I don't think I need to take you to. And my Lord Justice Mayles raised the point that mere shipping was decided this morning. I'm afraid I've not really had a chance to study it, but we would quite like the opportunity just to consider it and, if necessary, update the court. I don't think it expressly addresses this rule. It addresses a related point, which is where there's a force majeure clause, and that force majeure, effectively, there's a reasonable endeavours provision within the force majeure clause. Whether a party that is affected by sanctions that makes it not possible to pay in the contractual currency requires the other party to accept non-contractual performance.
Well, I've glanced at it, no more than that. The appeal was allowed. I don't think there's anything,
no,
at least at a very, very preliminary glance, anything in it. But if either party thinks that there is, then notify the court by, let's say, midday on Friday. We'll then give directions if people want to make submissions. But if we don't hear anything by midday on Friday, we'll assume that you're all content to proceed on the basis there's nothing there that needs to be addressed.
Well, I'm grateful for that indication. My Lord, in addition to the rule in English law about and Irish law about paying in the currency of the place of payment, where it's necessary to do so, the respondents would seek to imply a term to that effect. That's set out in Celestial Skeleton Argument of paragraph 66, and it's found support in the textbooks. I think Mann, in particular, paragraph 16.38. That's Authorities 2, tab 48, page 1385, gives particular support for that proposition. So we also rely on that. And my Lord, it is possible that the parties could have excluded that rule by expressly in the contract or by implication. But we say that in this case, no such exclusion arises. And it wouldn't be sensible to seek to infer that. The first point is that there's no language in the letter of credit or the confirmation which says that the contract must only be paid in US dollars. True, it identifies the currency of US dollars. But for this rule to apply, any contract would specify a foreign currency. The rule is an alternative to paying in the contractual foreign currency. So there has to be something more in the contract that would seek to exclude the rule. And here, we say that there's nothing in either the language or the nature of the agreement that seeks to do that. There's a payment to be made at an identified bank. It's the payment that's important. And if it's not possible to make the payment in US dollars, then the equivalent amount could be paid in sterling or euros. and certainly there's no uncertainty that's created by this rule, because the choice is either sterling or euros, and the exchange rate is on the date that the payment is to be made. My Lord, there's a tiny point about sanctions, which is my next point, and that is that so far as the blocking sanctions are concerned, they didn't come into effect until the 13th of April 2022. So on any view, they are irrelevant, because the payment should have been made well before that date. In relation to the captor sanctions, for Celestial and one of Constitution's demands, they were made before they came into effect on the 26th of March 2022. There are 4 demands by Constitution that were made on the 24th of March 2022, and we accept that the payment crystallised, or we say the payment crystallised on that date, and that there was then 5 business days to make payment. So we couldn't have sued. Sorry,
of the five Constitution demands,
one
before,
yeah,
captor, 4 on what day?
4 on the 24th, so 2 days before captor.
Yeah.
Captor comes in on the 26th. It was always within UniCredit's gift to make the payment before then, but we couldn't have compelled that. Can I then look at US sanctions, because that probably, as the judge did, addresses the captor point in particular, but I'll deal with both sets of sanctions. And just picking up and adopting the point my Lord Justice Mayles made, that this is really a question of fact, US law. The judge made findings of fact that were open to him to make on the evidence from the experts. He had the benefit of full argument on those reports, and this court shouldn't intervene to disturb those findings. There's no suggestion that the judge went beyond the evidence. There's a lot that's been said about OFAC and its role. It is, in our submission, irrelevant, because it hasn't made any finding or decision in relation to these particular sanctions, and it's not the relevant determinant of what US law is. But in any event, whatever OFAC says, it is subject to review by the US courts. And the US courts will set aside a decision by OFAC where its actions, findings and conclusions are arbitrary, capricious and abuse of discretion, or otherwise not in accordance with the law. And that's a proposition and a test that was agreed between the parties, experts, and was one which the judge rightly quoted in his judgment at footnote 57, paragraph 181. And can I just show you, it's in the joint memorandum between the experts, albeit it doesn't fully set out the test, but I'll show you the experts' reports, because in fact it is the UniCredit's expert who put forward the test as the applicable test. And one sees that in paragraph 14 of his first report, and that is in the supplementary bundle, tab 44. And that's at page 242. In fact, if one goes back to page 241, it's paragraph 14 at the bottom. It's the last sentence beginning on page 241, where he's saying specifically under the Administrative Procedure Act, a federal court will hold unlawful and set aside the agency action, findings, conclusions only when an agency's actions, etc. One sees the reference to the US statute there. That's a statement with which my expert, Mr. Ward, agreed, and the reference to that is at paragraph 35 of his report, and it's divider 53, page 299. And that's paragraph 35. And if there was any doubt about that, one actually has the extract from the statute itself in this bundle, and that's at divider 45, page 267, which sets out at paragraph 706, at the bottom of that page 267, a test for a review. And one can see that the reviewing court shall, in subparagraph 2, hold unlawful and set aside agency action findings and conclusions found to be arbitrary, etc. So that's the end of trying to put a gloss on that test. And insofar as Mr. Wall sought to use the word plainly wrong, that's simply shorthand for that test. It's no more than that. Insofar as the UniCredit in its supplemental skeleton argument, and indeed Ms. Barnes' submission to this court, seek to depart from that test, there's simply no basis to do that. And even the Consark case, which was relied upon, the passage that Ms. Barnes relied upon is part of the head note, which is not part of the judgment, so there's no weight to it. And if you then look at the authority itself, perhaps we very briefly look at that at SB Supplementary Bundle, tab 58, page 353. The actual decision of this case, page 353, right-hand column, there's a sort of square brackets 13 and 14. What the court says is that OFAC's determination was fully in accord with the general law governing letters of credit and thus survives our review. So it's doing no more than applying the test that I've showed your lordships, not expanding it in the way that seems to be submitted on the other side. My Lord, my next point is that the approach that the experts took before the judge below was very different. My experts sought to look at what US law was, whereas the UniCredit's experts sought to look at what OFAC would do, and they applied the wrong test. Now, it's important in this case is that there had been no reported case addressing these sanctions and the provisions we're looking at. So the relevant test you're looking at is whether the issuing bank is involved in the payment by the confirming bank from its own funds, and similarly whether the issuing bank has a property interest in the funds paid by the confirming bank from its own funds. There's no authority on that. So then what the experts have to do to help this court is to try and say, well, what would a US court do in that situation? And if you needed authority for that proposition, it's at Phipson, paragraph 33/96, and that's the authorities bundle, number 2, tab 51, page 1410. And one then turns to the captor sanctions. And in relation to the captor sanctions, as has already been covered, they were issued on the 24th of February 2022 and took effect on the 26th of March 2022. There are two limbs to it, and it's the second limb, and one can perhaps, it's easier to have it open in front of the court rather than my talking in the abstract. So that's supplementary bundle tab 40H. And it's page 277. And what it's driving at is just the first third of that, really, that one has to look at. So between the hole punches is effectively subparagraph 1, the opening and maintaining of correspondent account or payable through account. And then 2, the processing of a transaction involving a foreign financial institution determined to be subject to the prohibitions of this directive or their property or interests in property. And Spearbank was listed as being subject to these sanctions from their inception. So if one focuses on limb 2 involving Spearbank, the evidence that the judge had before him was Mr. Wall's report as to the purpose of the captor sanctions. That's at paragraph 49 of his report. Again, if we could just very briefly look at that, that's paragraph tab 53 of the same bundle. and that's at page 303. So paragraph 49. And again, if I could just invite the court to read paragraph 49, which explains what Directive 2 is seeking to achieve. And if you could just read on to 50 and 51. And my submission is that what Mr Ward is saying is that a payment by UniCredit from its funds to these respondents would not involve Spearbank in the relevant sense of the captor sanctions. What paragraph 51 of his report is showing is that under captor, involving Spearbank in the processing of transactions means where Spearbank is the source of funds for payment. And one can see an illustration of that in the FAQ 978 that he is referred to, and that's over the page, in the next tab, tab 54. Where again, it's at the bottom he gives a diagram, and one can see that here it's a payment from a third country originator. And the US involvement is in the middle, and the acceptable compliance is the first one, where it doesn't involve the target entity directly, whereas it's not permitted where there is a direct payment to the target entity. So the target entity here would be Spearbank. But that wouldn't apply to UniCredit. And if one goes over the page, one sees again from a US originator. And provided the bank is the payment is to a third-party beneficiary bank, that's acceptable. It's where it's directly to a targeted entity. Lord and Lady, just moving on. The US law also affords weight to the autonomy principle that one finds with letters of credit, and the position is very similar to that under English law. And one sees that from paragraph 59 of Mr. Wall's report, and so one can go back to the previous tab 53. Page 59, which is paragraph 53, sorry, page 306. And again, I'll just give that paragraph your ladyship's note, but it effectively applies a similar position to English law, and that the sole duty, the obligation would fall on the confirming bank from its own funds, and it would be liable in its own rights. Now, the US courts have had to consider the impact of sanctions on letter of credit obligations in a different context, with different sanctions regimes. And in those cases, as referred to there, what the US courts have done is to actually respect and uphold the autonomy principle with letters of credit. And perhaps one can see that illustrated in two cases, if I may. The first is the Semtex case, which is explained by Mr. Wall at paragraph 61. And perhaps it's easiest just firstly to read paragraph 61 at page 308 to just get a sense of the Semtex case. Then if one turns to the Semtex case, that's at tab 57. And one can pick it up at page 330, which is of the bundle. Internal numbering would be page 3 of the report, and that's where the opinion of Judge Stand starts. And what's illustrative, and perhaps I could just draw your attention to, is on the right-hand side, the penultimate paragraph in that section. Starts, Semtex and Eaton brought this action only after applying twice for licenses from OFAC. The first attempt, an application with UBAF's consent, was for a license that would allow UBAF to pay the plaintiffs from its Iraqi assets.
Sorry, I thought I had it, but I seem to be in the wrong place. What did
330?
330.
I thought, sorry.
I know. Yep.
And it's that right-hand column, and it's
Yes,
the penultimate. And so effectively there were two attempts to apply for the license. One was to use blocked funds. The other one was to actually, the payment to come from UBF's own funds. The blocked funds application was unsuccessful. The application against UBF's own funds was successful. And I'll rely upon that when I come back to reasonable measures in a moment, but I just draw that to your attention. And then the bank then sought to argue that, in fact, even its own funds, because of the obligation to make reimbursement, should be treated as the sanctioned party's funds. And that was an argument that was rejected by the court. And one can see that well, perhaps turn on to page 337. And it's at the bottom of that page where effectively at paragraph 3 it says, this independence principle has been held dispositive of the issue before us by a few courts. So that's dealing with the autonomous point. And that's then relied upon to reject the argument that there is any interest held by the sanctioned party in the payment of funds that has to be made by the unsanctioned bank, in this case UBAF. And again, I'm conscious of the time, so perhaps I'll just draw your attention to page 337 from paragraph 3, and then just to page 338. On the right-hand side, the end of the second big paragraph. And I would highlight just on the right, first column, Iraq's interest in the restitution from the bank or from the beneficiaries entirely separate. And that's,
sorry, I'm
on the right-hand side of page 3.
Just below the end of the quote.
Yes, exactly. Just very briefly, the other case, which is the one referred to there, is the centrifugal case, and that's at tab 59 of the same bundle, page 356, which again made the same point. The right to restitution is entirely separate. But that case is quite a striking case, because in that case, one can perhaps pick it up at page 358 of the bundle. One has an application that was made by the United States itself, the government, in which it effectively sought to stop the payment of funds under a letter of credit on the basis that this should be considered as the property interests of Iraqi. And that's at 1351, if one sees the little numbering there on the left-hand side, first column. So just very briefly, the facts of this case are that there was a letter of credit given as security for a contract to be performed. There was then a standby letter of credit for reimbursement. The contract wasn't performed. The standby letter of credit expired. So there was then the proceeds from the letter of credit that were held. And the row was what would happen to those proceeds. And the bank holding it interpleaded to try and return it to the one of the other parties, but not Iraq. And the United States then intervened to say that Iraq may well have a property interest in that repayment. So that was the essence of it. And the important bit is just at 358, the first paragraph, where the government argument was that there was a national interest and a policy consideration that Iraqi property interests should be construed broadly. But what the court held was that they were not persuaded that these policies would be furthered by construing the circumstances here to give rise to a property interest on behalf of Iraq that would not otherwise be cognizable under governing legal principles. Iraq would not be punished if denied use of the assets in which it could not claim a property interest in the event. And that argument is then supported by the autonomy principle that is then explained over the next 2 pages before the conclusion that you will see at page 360, reiterating a point at 1354. So those cases, Sebtex in particular, but also centrifugal, support Mr. Wall's opinion at paragraph 62 of his report that payment from UniCredit's own funds and not from Spearbank's assets wouldn't fall within the scope of the captor sanctions, or indeed, you would say also the blocking sanctions, because it's not a property interest. Now, UniCredit rely next on the enforcement action that OFAC took against the UBF in a different case. That was a Syrian case, if you remember. And again, the judge distinguished that case, and he was right to do so. Mr. Wall also explains the distinctions of paragraphs 52 to 56 of his report, and that's at supplementary bundle, tab 53, pages 304 to 6. But I think 2 important points arise. The first is that there was clearly a dealing with a sanctioned party by the bank, and that obviously transgressed. Second,
Sorry, I didn't catch what you just said. I'm sorry.
I'm so sorry.
Could you say
No,
that?
no. So in the UBF prosecution by OFAC, there are a number of distinguishing features, and the 2 that I would highlight are first, that the bank UBF was actually dealing with a sanctioned entity in processing transactions and the like. The second was that it opened letters of credit after it had become sanctioned. And those are important differences. And obviously the third is that was a blocking sanction rather than a captor type sanction. And my lord, many of the points that I've made in relation to the captor sanctions would also apply to the blocking sanctions. And specifically, the 2 points that UniCredit rely upon is first that there's a dealing with Spearbank's property or property interest. Well, the cases I've shown you don't support that argument, and I'll say no more. In relation to providing a service to Spearbank, again, that is something that is not supported by the evidence. All that is sought to be relied upon is the UBF enforcement decision, and I've addressed you on that, and why that is and was correctly distinguished from this case. The final point is on US law is whether UniCredit took reasonable steps to seek consent from OFAC. And that really had 3 points put in our skeleton argument. The delay, the failure to engage with OFAC, and third, the actual application that was made to OFAC. I'm just going to deal with the last one orally. I adopt them all, but orally. In relation to the OFAC application, we do say it was flawed because it bound up with it a payment from the blocked funds of Spearbank. And again, one can just go back to the OFAC application at divider 12 of the supplementary bundle. That's a page, divider 12, page 126.
This is the celestial one, isn't it?
It is the celestial. There was one.
We assume there's one in
Yes.
similar form.
Unless you see anything different, you can assume that it is the same for both parties. And one sees that right at the beginning it leads with the Spearbank, payment from Spearbank, and then the purpose is to forward funds on to a non-sanctioned entity. And then one also sees at page 129 and page 130, again, that linkage that's there.
I suppose the very bold heading of the letter itself gives you some idea of what you say.
Yes, exactly. But one only has to see what happened in the Centex case, where you're looking to effectively use blocked assets. That is going to make it a lot more difficult than using your own assets or funds to make the payment. And that showed in the sense that they didn't try and make it as streamlined and expeditious and simple application as they could. Now, we don't know what OFAC would have done had they made a straightforward, simple application. There's simply no evidence before this court.
So what's the consequence then of that?
Well, the consequence is you can then go back to look at what happened in the Centex decision and to take some view that actually a simple application from UniCredit's funds that didn't involve Spearbank releasing its funds was likely to have been approved and approved in a reasonable time frame.
The judge didn't deal with this issue, did he?
The judge
don't have any findings about that.
No, he didn't. He didn't. He took the view. I have some sympathy.
You've done enough.
This is all enough of us. But this is all academic because of his finding on the timing, and therefore, and given his earlier findings, he didn't have to deal with it. Well, Lord and Lady, I've gone through at great pace, but unless I can assist you or need anything further on this, those are my submissions.
All right. Well, thank you very much, Mr. Shaw. Mr. Quest, anything in reply?
Can I start, please, with the regulation 28? And can we take up regulation 28? And what I just wanted to do was, page 86 of the bundle, is to focus, in the light of the, what you said on behalf of the claimants, focus on the definition of a qualifying arrangement, which in 28.3 is, one just sort of underlines irrelevant words, it's an arrangement whose object or effect is directly or indirectly making restricted goods available for use in Russia.
And one of the questions discussed this morning was what is the arrangement here, and what does the word arrangement cover in relation to these aircraft leases? And as I understood the argument advanced this morning, the claimant's primary case, at least, is that the arrangement, or the relevant arrangement, is made by the execution of the lease. They then say, since that arrangement was made in 2005, at a time when the sanctions did not extend to aircraft, then it's not a qualifying arrangement. And the status of the arrangement for sanctioned purposes, they say, is established at the point when the lease is made, which predates the sanctioning of aircraft. Now, that combination of arguments has the surprising consequence, as Lord Justice Snowden pointed out in argument, that Regulation 28 would not affect the provision of funds in relation to a lease made, say, in February 2022, even though aircraft might be made available under the lease after March 2022. So something's obviously gone wrong with the way in which the claimant formulates its primary case. And what I want to try and do is suggest how one should read the regulation in order to put that problem right. And the first important point in terms of interpretation is what I might just loosely refer to as the label point. In other words, how does one read and understand the bracketed reference to restricted goods? And we says, as your Lordship knows, that is simply a label or a placeholder for a set of particular things, of which aircraft is one, so that for the purpose of analysing the regulation in the present case, one can simply substitute the word aircraft for restricted goods. Now, the claimants say actually what one should be substituting is not just the word aircraft, but the phrase, I think this is what was said, the phrase aircraft that are the subject of prohibition from March 2022. But not only is that not what the words say, and not the literal meaning of the words, but approaching it in that way would appear to be circular, because the whole purpose of the regulation defining restricted goods is to define what is prohibited, or to define the scopes of the prohibition. And if one makes the substitution in the way that we suggest you should, then one has effectively got a regulation that says an arrangement whose object or effect is making aircraft available for use in Russia. And that's the wording that one's testing against. And it's relevant in my submission when one looks at that wording, that the regulation uses the words object or effect, which have slightly different meanings. Object, as a matter of language, looks to purpose and intention. So when one talks about the object of the arrangement, one is looking at what is its purpose and what's its intention. Whereas the effect of the arrangement slightly more indicates what actually happens under the arrangement. And both expressions are used. Now, just going back to the claimant's primary case, they say, well, one should ask this question at the point when the lease was executed. Well, once you've done that substitution, if you ask the question in 2005 in relation to the present leases, in 2005, one goes back to 2005 and asks oneself the question, is the object of these leases making available aircraft in Russia? And then obviously the answer is yes, of course, that's the purpose of an object of an aircraft lease. And it also, reading the regulation that way and making that substitution, in my submission, solves what otherwise appears to be an oddity, as Lord Justice Snowden raised, Because if you go to your February 2022 lease now and sort of transport yourself back in time to February 2022, and you say, well, is the object of this lease to supply aircraft for use in Russia? Again, the answer is yes, that is the object of this arrangement, even though no aircraft may be delivered until sometime in the future. So that object might not be carried into effect immediately, but nonetheless, that is the object of the arrangement. And thus, on that reading of the regulation, the lease in that example, the February 2022 lease, would be a qualifying arrangement and would be caught by the regulation. Again, if I'm just still sticking for the moment with the claimant's primary case, that same kind of analysis applies to the leases in this case. I mean, there's no doubt at the date they were executed in 2005 or whenever it was, they had the object of making aircraft available in Russia. And importantly, and this I think is where we seriously part company with the claimants, for the purpose of deciding whether the lease is a qualifying arrangement for the purpose of the 2022 regulations, it is irrelevant that at the time the leases were made, the object was not then a sanctioned object. It is sufficient that the object was to make available aircraft in Russia. It was not necessary that that object should have been prohibited or controlled at the time. Indeed, we would also say that if one is talking about the object of the lease, and keeping in mind that distinction between what the purpose or intention of the arrangement is and what actually happens under it, the object doesn't change in that sense. It was the object of the lease in 2005, and it was still the object of the lease in on the 1st of March 2022 when the regulations were made, and at that point the object came within the scope of the regulation.
Well, you could also say following termination.
Exactly so.
You're
Exactly, and I was
got to work out what the object is.
Exactly. If you anticipate me again, but just before I get to that point, I would say, and if one winds forward to the date when the regulations came into force, 1st of March 2022, again, the object of the lease was on that date too, still to make available aircraft in Russia. And indeed, on that date, the effect of the lease was also to make available aircraft in Russia, because as of that 1st of March 2022, I think, at least possibly with one exception, the aircraft were still in Russia. And it's important, I think, to bear in mind in considering these arrangements that we're concerned with lease arrangements, which are in principle continuing arrangements, as opposed to a sort of one-off sale. And so a lease continually makes the leased item available to the lessor. Now, to take up my ladyship's point, and then obviously at some point after the 1st of March 2022, the leases were then terminated. And that may mean, in one sense, the leases cease to have the effect of making the aircraft available in Russia, if that was what the contract provided. But when one's thinking about the object or purpose of the arrangement, that shouldn't, in my submission, be regarded as changing over time. The object of an aircraft lease, if I can put it this way, is, was, and always will be the supply of aircraft, albeit that object may not always be achieved, or may only be achieved partly.
I think perhaps you're coming to it, but I think the point against you on termination was, or at least included, that once the leases were terminated, there was no arrangement at all.
Right. But
what do you say about that?
That is the point I was about to make. That, again, that is in my submission, really to approach the case on the basis that once the agreement is once the arrangement is terminated, it should be treated in some way as if there never was an arrangement.
Do you need to say that? I mean, the prohibition is against providing financial services or funds, and let's focus on funds.
Yes, because that's
it's either in pursuance of or in connection with.
Yeah.
I can see that it's more difficult to say that a payment of funds is in pursuance of an arrangement if the arrangement has ceased to exist. You're not pursuing the arrangement anymore. But I think you have always placed your reliance on the words "in connection with," which is a looser. It's a looser form of connection.
Exactly so. And sorry, I mean, I focus in these reply submissions on arrangement, but I don't want to lose sight of the submissions I made in opening, which is the importance of the word connection to the arrangement, whether that's a terminated arrangement or extant arrangement. It is still a connection. In relation to that, I should perhaps just make this point. It was said by the claimants in their argument that the way this regulation operated, the financing or the payment of funds, had to be for the purpose of enabling or facilitating the supply of aircraft. But that, with respect, is just not what that's not what the regulation says. The regulation could easily have said that the prohibition is on the provision of funds if that would enable or facilitate the supply of aircraft, and perhaps that would have been a sensible way, or a possibly sensible way of drafting the sanction. But for whatever reason, the drafters have not approached it in that way, and the nexus that they have decided on between, on the one hand, the payment of funds, and on the other hand, the arrangement. And I should make it clear that the relevant nexus in the legislation is not between the provision of financial services or the payment of funds and the supply of aircraft. It is between the provision of funds and the arrangement. And the relevant nexus is expressed in terms of connection rather than in terms of causation, which I think is the point my Lord Justice Snowden was asking me about. So if one sees it in that way, then the termination of the arrangement doesn't really affect the test that someone in the position of UniCredit has to apply, which is there a connection with an arrangement that has a relevant object or effect. I should make this point also, that there is, in viewing the regulation in what I suggest is a relatively straightforward way, without any need for any embellishment of the language, there is a rather important practical benefit in the sense that it avoids the need for the financing party like UniCredit, on whom the sanctions may bite, to embark on some kind of investigation about what has in fact transpired under the relevant arrangements. Have they been terminated? Are they continuing? What's the consequence of termination? And we saw yesterday that, unsurprisingly, as a confirming bank with an autonomous obligation, UniCredit didn't really know anything about the leases and had to, in order to make its licensing application, had to ask for information. So it wouldn't, I mean, and looking at the position more generally, one wouldn't necessarily know, for example, whether the lease was paid in advance or arrears, whether a termination had taken place, what the effect of the termination is on the access to the aircraft, and what the consequences there are in that respect if funds are paid or not paid.
Or indeed whether a termination was challenged.
Or exactly so. Exactly so. I mean, just to take one example of that as to how it might make all the difference in a way that just wouldn't be apparent to the party providing the financial services or the funding. Mr. Shah, when he went through the terms of the particular leases in this case, made the point that these particular leases on termination do not provide for a purchase option. So in these particular leases, the lessor does not have the right to keep and pay for the aircraft. I'm not sure that's right. But there may be other kinds of arrangements where the aircraft can be retained if it's paid for at the end of the lease, or some other arrangement of that nature. And of course, all of that that information would not be expected to be available, or might not be expected to be available to a person who was providing financial services or funds. So one can see I think one approaches it in that way, one can see why it's being drafted in this way, and why a relatively broad and simple test is applied, which is one of connection between the provision of the funds and the arrangement, and all the person has to do in order to see whether he comes within the sanction or not is to know what the object or effect of the arrangement is. And so, and that therefore is the interpretation we say should be put on it. I mean, I've approached this in reply by discussing the claimant's primary case. I think possibly in the face of the difficulties that arose on some of the examples, it would say, well, there could be an alternative case which expands the definition of arrangement to cover not just the making of the lease, but also, for example, the supply of the aircraft under it. And that may, of course, have the sort of forensic effect of solving the problem that was raised by Justice Snowden in the example. But it doesn't help the claimants in this case, because obviously by expanding what comes within the concept of arrangement, they are simply bringing more things within the scope of the sanction. So it's really for those reasons that we say Regulation 28 ought to be interpreted in the way that UniCredit understood it. I should, just before I move on from Regulation 28, I just want to say something about purpose. It is a feature of this scheme, as I showed you, Lordships and your Ladyship, that there is a requirement in the primary legislation that there should be a statement of purpose in the secondary legislation. And that's what we see in Section 4 of the regulations, where we looked at it already, it sets out the purposes, and they're very, very broadly drafted in terms of encouraging Russia to seize actions destabilising Ukraine. Now, in the course of argument, and it's natural to understand how this happens, the claimants glossed that or restated that in various different forms. It was said, well, the key purpose is to stop the supply of restricted goods to Russia, or it's designed to cut off the supply of financing, or it's designed to stop further aircraft coming into Russia. It's put in lots of different ways. I would respectfully suggest one needs to be somewhat cautious if one's, I mean, to the extent that it's appropriate to look at the purpose to interpret the regulations, to depart from the express purpose in the terms in which it's stated in the regulation, pursuant to the requirement to do so in the primary legislation. And in a sense, it doesn't help. It's been stated in a particular way. It doesn't help to try and restate that. And obviously, we make the point that it has been stated deliberately in an exceptionally broad way, with all the consequences that we discussed yesterday about casting, potentially casting the net too wide in some cases, tempered, of course, by the existence of the licensing regime.
But that last point is because if you just look at purpose 4A, yes, the riposte which comes from the respondents is it's not going to discourage, it's not going to encourage Russia to cease actions in Ukraine if you stop your client paying them. Neither, I mean, why does Russia care about that? Sort of thing?
Quite, and I accept that.
And so you have to, if that were your sole stopping point without the licensing regime, that would be actually quite a good point against you. But you say if the net that's designed to achieve that end is cast a little bit too widely, the way of mitigating that problem is the licensing regime.
Well, I would suggest, with respect to that, wouldn't, to put the point in that way, which in a sense is the way in which the judge put it when he talked about standing back and looking at the particular parties here. That risks this error, this sort of analytical error of not, rather than using the purposes as the context in which one then goes to look at the particular sanctions, and obviously there are a large number of slightly different sanctions. That risks the error of sort of substituting the statement of purpose for the particular rules, and then saying, well, on the facts of this particular case, these particular facts wouldn't advance the overall purpose, and therefore the sanctions can't apply, and that wouldn't be the right way to look at it. The only relevance of the purpose is to give the court context in interpreting the words of the sanctions, but ultimately it's the words of the sanctions that so to focus, to sort of compare the facts of a particular case with the broad purposes of the sanction is not a valid approach in my submission. And the consequence of the sanctions being drafted in the way they have been, in the context of variable purpose, may result in some cases being brought within the net that in hindsight one might think, well, actually we could have, the sanctions maybe didn't need to go so broadly to achieve their ultimate purpose, but the answer to that is the licensing regime. Well, unless anything else on Regulation 28, I was going to move on to Section 44.
Yes.
I wasn't proposing to say anything about actual belief or reasonable belief. I think you have my submissions on that, unless there's anything.
No, that's been covered quite fully.
Yes, it has. I wanted, however, to look at the sort of second part of the argument, which is, well, what protection do we get from Section 44 if we satisfy the condition of having a reasonable belief that that we couldn't pay because of the sanctions? And again, can we turn up Section 44? It's on page 32 of the authorities fund. Now, just starting perhaps with thinking about the purpose of this provision, and in my submission, it is essentially, as Lord Justice Snowden suggested in argument, it is intended to ensure that a person does not feel pressured to do something or not to do something which he reasonably believes to be subject to sanction for fear of exposing himself to civil liability. That, I suggest, is the purpose. And that the fear could include, there's no reason why it shouldn't include, exposure not just to claims in damages, for example, but also to claims for interest and claims for costs. If, for example, his actions prompt his counterparty to sue him. And I should just make, just while we're talking about interest, because this was something that was discussed this morning, there was a thing about a little debate about whether payment of interest would ever have any adverse consequences on party the position of UniCredit, because in essence it's calculated to reflect the time value of money. My answer to that is, first of all, this provision, of course, has to be interpreted not against the facts of this particular case and this particular claim, but against the possibility of all claims or all liabilities that might be envisaged. And there are many cases in which the payment of interest would be adverse. It all depends on ultimately on the rate of interest that's being charged against you, or the court's ordering against you, and the cost to you of obtaining that money. And of course, if interest is only awarded at the same rate at which the defendant himself can borrow or secure the money, then it is indeed a wash. But that's certainly not always the case. And indeed, if the claimants had their way, it wouldn't have been the case in this case either, because in fact, if your lordship, that's the judgment tab 16, you'll see there was a discussion of interest beginning at paragraph 18 on page 254. And there was indeed an argument about rate. And you'll see that at paragraph 19, Celestial and Constitution were both seeking interest at prime rate plus 2%. So they were asking for a higher rate than the market rate. The judge doesn't explain the reasoning for this, but one imagines that the basis for that argument would have been what one sees at paragraph 20C, with Justice Fox in the Lone Star case, which is that some claimants may have to pay a higher bank rate, and certainly a higher bank rate than a wholesale bank. But at any rate, I mean, in this case, it was argued that there should be not a punitive rate of interest, but a rate of interest which might well have left UniCredit out of pocket. Now, in fact, UniCredit was able to persuade the judge that it should be prime rate only. So to that extent, on the facts of this particular case, it may well end up.
When you say it was left UniCredit out of pocket, I'm not sure.
In the sense that if UniCredit, if the cost to UniCredit of raising US dollar funds is US prime, and or the rate at which it can earn on funds is US prime, and it has to pay at US prime plus 2, there might be a mismatch between the interest rates. That's what I'm saying. In other words, if a party is ordered to pay interest at a particular rate and earns interest at a different rate, then or receives funds at a different rate, then there's going to be a mismatch. The main point I'm making
It's
is
hard
that
to think that Parliament would have had that degree of granularity in mind in Section 44.
No, and I'm not suggesting that they do. All I'm saying, and I think I would say Parliament looked at it as a matter of great generality, and they covered all civil liability. I'm simply responding to the point that it is said, I think, against me, that actually one should not include claims for interest within this particular provision, on the grounds that it would never leave the defendant out of pocket. I'm simply making the point that there's nothing in the section which suggests that interest or claims for interest have some special status, nor as a matter of principle is any particular reason to treat them differently for any other claims, for any other relief. And I mean, if one looks at the wording of section 44, I mean, just looking at section 2, it uses the language of liability to civil proceedings. So, and this is potentially an important distinction, it is not excusing the person from an obligation. It is simply saying that they will not be liable to civil proceedings for the relevant act or remission. And the person is not liable to any civil proceedings to which that person would, in the absence of this section, have been liable in respect of the act or remission. Now, that means that the question I suggest that one needs to ask in this case is a simple one. It is, absent section 44, would UniCredit be liable to the claimants in respect of its non-payment of the LC? Because that's the omission we're talking about. And the answer to that is, in my submission, plainly yes, of course it would be liable in respect of its omission. And indeed, the claim that's made against us is explicitly for the failure to pay on the due date. So we would, in the absence of section 44, unquestionably have been liable in respect of our failure to pay. And the effect of section 44.2 is quite simply to say that we are not liable to those civil proceedings.
Do you accept, as Mr Hobson submitted, that if there had been no licences, so it remained a claim for the principal amount,
yes,
then they would have been entitled to sue you. The judge would have been entitled to decide whether Regulation 28 gave you a valid ground not to pay, and if he concluded, as he did, that it didn't, then he would have given judgment for the full amount of the claim.
No.
So he couldn't do it. So the judge has to decide, does he, that you don't have a defence under Regulation 28, but merely because you reasonably believe that you do, you can't be made to pay.
To be clear, what I'm submitting is that the effect of section 44 is that the claimants could not bring a claim against us or in debt, let's say, or damages, or non-payment of the letter of credit, because that claim is exactly the kind of claim that is envisaged in section 44. So they simply couldn't have brought that claim, they couldn't have brought it in debt or damages, and therefore they couldn't have brought the associated claim for interest and costs. I mean, that's...
So could they bring a claim for a declaration that section 28, regulation 28.3 doesn't apply?
Well, that is, as I said before, is the way we would suggest that the court might.
So if they get the answer, no, it doesn't apply.
Yes.
They then are prevented from suing you for the debt.
No, because once they have got the answer, so once the court has opined on the issue, in other words, once the court has said.
No, but the act was done. The act was done, i.e. not paying in the reasonable belief. Or are you saying that, as it were, the continued failure to pay can be in the reasonable belief?
Exactly. We could no longer hold the reasonable belief that the regulation applied once the court had determined that it did. And that I suggest is the way in which one can and should reconcile Section 44, which is clearly intended to provide very extensive protection, with the need ultimately for the court to express a view on Section 28. But what Section 44 clearly doesn't entitle the claimant to do is to bring proceedings against us in which they claim debt or damages in respect of the very non-payments which we've made, which falls within Section 1. They can't bring those proceedings. If they do bring those proceedings, then they're not entitled to the cost of them, and equally, if they can't bring those proceedings, they equally can't bring a claim for interest. Unless and until it has been established what the position is under Section 28. And then, of course... I mean,
I'm sorry, would you add to that establishing the position under Section 44? Because you said bring a claim for a declaration under Section 28, but it might also be relevant to determine, as the judge did, whether Section 44 was in point.
Yes, and I mean that must ultimately be justiciable. They must be entitled to ask the court.
So you would say that would be by way of declaration as well?
Yes, well, it would have to be, because there's no statutory right of action. And you know, once a substantive question about the application of Regulation 28 has been established by the court, well, then thereafter we have the choice. We can either accept that and recognise that we no longer have any reasonable belief for non-payment, or and pay, or we don't, in which case we're then liable to proceedings in the normal way for non-payment where we have no defence. So that, I suggest, is the way in which the section works. And to read it in any other way, I suggest, really makes it essentially redundant. I mean, if as I think at one point was being suggested, that the court should first of all entertain the claim for debt to the extent of deciding whether it was or wasn't prevented by Regulation 28, and then, having decided that, only then go on to consider Section 44, that would make Section 44 completely redundant, because once the court has decided on the substantive point, well, the question of reasonable belief never really arises, because everyone knows what the position is. So Section 44 only really has any value if it protects you from substantive claims, including claims to enforce obligations which you reasonably believe under the sanctions you cannot satisfy.
So sometimes Section 44 has what one might think of as a temporary effect. That's to say, you have a reasonable belief that you're not obliged to pay the debt, and the court ultimately holds that you do have such an obligation because Regulation 28 doesn't help you, and your obligation then re-arises. So because you say you no longer have a reasonable belief, once the court's given a ruling. But in other respects, it has a permanent effect, does it? Because suppose the claimants suffer damage over and above non-payment of the debt because of not having the money. They lose some vital piece of business or something like that. But you would be permanently protected from liability in respect of that if you have a reasonable belief, even if the court tells you later that you were wrong about Regulation 28.
But that is, in my submission, inexplicable because one's talking about two slightly different things there. In the first example, it's not that the obligation, of course, is always there. It's just that you cannot bring civil proceedings to enforce the obligation. If the defendant is acting in a reasonable belief that it's not payable because of sanctions. Once that belief has been dispelled, if I can put it that way, by the court, then it is open to you to make a fresh claim or make the claim on the debt. The debt is then payable, and the continued omission not to pay it will result in a remedy in the normal way.
Yes, but if during the period you had the reasonable belief, you weren't paying and that caused some other permanent damage.
That I agree, you would not be able to recover.
Yes. Because I raised the question earlier about what the difference is between that sort of consequential loss.
Right, but
interest.
Yes, it is a it is different because the interest is something that only arises when you're entitled to bring the claim. It can only be brought as part of the claim. I mean, the point in this case, I mean, if we just sort of focus on what happened here, the objection we have in this case is that we have been put in a position where we've had to answer a claim which we shouldn't have had to, because we say that Section 44 prevents those proceedings being brought.
I think your point is you get a absolute protection against all consequential losses, which might be suffered as a result of your non-payment until you're told what the true position is, and that would include interest, and it would include any other consequential losses that somebody might suffer. The entitlement will just put to you, for example, loss of business or something else like that.
Right.
But your liability only restarts when the court disabuses you or something happens to disabuse you of the reasonableness of your belief.
And then once you're disabused, then the claimants are in the position that they would normally be in.
Prospectively.
They can bring proceedings. What they can't do is anticipate that, effectively, by bringing the proceedings in order to have the substantive issue under Regulation 28 determined as part of their claim in debt. And that's what we say was invalid in this case.
But if the proceedings that they are entitled to bring for a declaration say, which I think you accept they must be entitled to bring, trigger a liability in costs because you lose, you're not protected from that.
If I think I would have to accept that if the proceedings had been brought only by way of declaration, and we had, which of course needn't involve us, because the declaration, obviously we're an interested party, but we don't have to make any submissions on it. There are many other parties that might be considered to be, obviously, and so on, appropriate interested parties. But declaration is something the court does. It's not a remedy against. It's not a. It's not a remedy. Sorry.
You would be party.
We would have to be party to proceedings, but we wouldn't have to participate. If all we were interested in is, as indeed we were, of knowing what we should be doing, we needn't take a view one way or the other. And I can see the argument had this been the way in which it come out, that if the claimants had proceeded in that way, and we had sort of weighed in with a sort of positive case on the declaration, then of course the court might say, well, that's because you chose to
Well, that's exactly what's happened, isn't it? You have chosen to not only make a positive case under the declaration, but to rely on US law and on parts of the regulation which you lost on below and don't pursue on appeal. You could have simply said, all we say is Section 44 of SAMLA, nothing else.
We could have said that, and it's right to say that in some respects our defence did go further than that. I think in relation to the Regulation 28 point, I think what I would say is that in reality, the difference between, given that we had to argue that we reasonably believe the position under Regulation 28, the distinction between that and what the position actually is it's essentially the same point. There's perhaps more force in the US regulations point, which obviously is a different point, and ultimately that might have to be the court's awarding costs. I mean, just as it would in any case where a party has been successful on one but not all issues, then maybe the court ought to take that into account. But in principle, we say the starting point ought to be that we shouldn't have had to appear in these proceedings because they shouldn't have been brought in the form in which they were. And having, if we're right about Section 44, if we have a defence to them, the successful party, what the court then chooses to do about other defences we ran which were unsuccessful.
Well, it's always a pleasure to hear a party represented by 3 leading counsels admit that it shouldn't really be there at all.
Well, as I say, it was we are the defendants here, so the reason we've had to participate in these proceedings is because we were faced with a claim for debt and for damages and for interest.
Actually, you're the appellant here. You could have just accepted the first instance judgment if you were indifferent about it.
Except that the first instance judgment was not limited to the point which
it has made you pay interest and costs, and if you want to challenge that, then you have to.
Yeah. So, and of course, none of this would, if this case hadn't been pleaded in the first case as a claim for an order that we pay money to them, including interest and costs, then we wouldn't have any complaint. But having been put in that way, what are we supposed to do? We could say, well, okay, we'll allow judgment to be entered against us, but then we'll end up paying interest and costs which we're not liable to pay. So,
right. Anything more on SAMLA?
Nothing more on. Just give me 1 moment. No, nothing more on SAMLA. Briefly on, very briefly on Raleigh Brothers, and then I'll let respond the same things you want to say about US sanctions. Transfer versus payment of cash. Can I just deal with that point first? Obviously, I mean, ultimately, it's a question for interpretation of what those words mean in the contract. But I would suggest, on any ordinary usage of those words in a commercial and banking context, there is a difference between an account transfer and payment in cash. And nobody would ordinarily think, if one asks for a transfer into your bank account, that someone's going to proffer a bag of banknotes. And to the extent that it provides some help on this, it may just be instructive just to look at the way Mr. Justice Staunton looked at things in Indian Arab Bank. If you just turn up page 575 of the Foreign Fund or Means of Transfer. I mean, it's just perhaps instructive to see how his lordship approached it. He said, at bottom, this is just above letter C, at bottom there are only 2 means by which the fruits of that right, chosen action, could have been made available to the Libyan bank. The first is by delivery of cash, whether dollar bills or other currency. The second is the procuring of an account transfer. So he obviously saw them as different things. And I mean, we have a contract in this case which sets out with great specificity how the transfer must be made, the currency, the need for a bank account. And as I said in opening, all of that has to be, when one looks at the provisions for payment in the LC, one has to see them against a background of strict compliance and the need for UniCredit not to step outside the scope of its instructions from Sparebank if it wants to be indemnified. So then just, so payment of cash, we say, is fundamentally different from a transfer. I think just to deal fairly briefly with three of the points Mr. Sharp raised. First of all, he put a lot of stress on the point that the place for performance here was either the UK or Irish bank accounts, and he showed you, I think, some mainly academic or text authorities suggesting that the place of performance is where the account is located. But the point about bank transfers in foreign currencies, and this really was the point in Libyan Arab Bank, is that they do require performance, or very often require performance, in different places, both in the place, or different places simultaneously, both in the place where the account is held and in the country of the underlying currency where there will be payments or settlements between correspondent banks. And I mean, if Ms. Justice Staunton was right in Libyan Arab Bank, it simply can't be right that the only place of performance is the place where the receiving bank account is held, because, as mentioned in argument, if that was right, he wouldn't have needed to consider any of these points at all, because that would have been a complete answer. He wouldn't need to consider cash payments. On the factual question.
So if a contract, I mean, the point that was made against you is that the contract actually says it's a payment obligation, and that it said the requirement for transfer is just the means of settlement, or administrative means. But if a contract was construed to require a bank transfer,
yes,
in the international context, can there ever be a place of payment for the purposes of application of this rule? Because by definition there will always be two places for a bank transfer, one where the debit is made from the payers, and the other being the debit as a credit to the payee's account. So how does the rule just simply have no opportunity? What is the rule? How do you apply it in those circumstances, if at all?
Well, I mean, one's looking at how it applies in the Raleigh Brothers context, and I think the answer is that in those circumstances there are two simultaneous places of performance. There's no reason why there shouldn't be.
But maybe only one contractually provided for, because the contract typically provides for the payee's account. It doesn't specify where the payers.
That's right. But in circumstances where, in order to achieve payment into that account, performance necessarily requires things being done in the other country.
Yes, that's the critical point.
But then you have to say, is it necessary for the payer to perform its obligation in a country where it is prohibited, or could it perform in some other way, which is a question of fact?
Yeah, and I accept that necessity test. If there was a way of doing it without that, then the argument doesn't run. But ultimately, that is a question of fact. In relation to fact, I showed you what the evidence was before the judge. There was no, I mean, and as I explained in opening, that wasn't really challenged in any way. If it had been challenged, then maybe some of these points could have been explored further. There's now effectively a sort of belated attempt to go behind that by showing the court comments in textbooks and so on about possible payment mechanisms. But it is right that, I mean, ultimately it's a factual question, and it has to be decided on the evidence. We say on the evidence that the court has, it can find consistently, broadly, with Libyan Arab Bank that the dollar payments would require performance in the US as well. And just finally on this, payment in euros or sterling, you were shown the passage in Dicey, it's on page 1359, 1360, and I looked at it with you when we looked at Libyan Arab Bank. The only point I just wanted to stress again is 37053. This rule, in other words, the rule that you have the option of paying in different currencies, is, as Dicey says, primarily a rule of construction. And that also, I suggest, is how Mr. Justice Staunton saw it in Libyan Arab Bank, in saying that it was subject to what the parties had agreed. And in this case, so whilst that it may apply in some contracts, in this case we have a specific mechanism for payment, exclusively, we say, in US dollars. And that's the only way in which the credit could ever have been operated, because it's the demand had to make a demand for a transfer of dollars. And I also, nothing was said about it, but just so we don't lose sight of it, I do remind the court that in relation to all of these arguments about either payment in cash or payment in different currencies, it's not suggested that the claimants ever made any demand for any of those methods of transfer, and therefore my submission in somewhat ought to say that that UniCredit should in effect have volunteered. That's all I was going to say. Unless there's anything else I can help you with, I'll hand over to Ms. Barnes.
Yes, thank you very much. Ms. Barnes?
My Lord Fanning, 4 points, please. First, it was said that we put a gloss on the test of judicial review in the United States. In answer to that, okay, well, if there is any such gloss, then that is one that was identified by the respondent's own expert, Mr Wall, and we looked yesterday at his report. And perhaps I'll just give the reference rather than ask you to turn it up given the time, but that's at paragraph 65 of his report, where he identifies the plainly wrong test, and the bundle reference to that is in the supplemental bundle, tab 53, page 310. It's electronic page 318. Mr Sharp took you to the Consark case in relation to this point, and I would ask to turn briefly to that. That is again in the supplemental bundle, tab 58 at page 353. The electronic page is 361. You'll recall when I dealt with this yesterday, I dealt first with the head note and then with the substantive discussion by the court. Page 353 is where the substantive discussion is. And I would ask please to look at first on the left-hand column, following the numbers in brackets 9, 10 and 11.
Well, these are the passages you took us to yesterday, which finish up with the words plainly wrong at the top of the right-hand column.
Yes, but there's just one point which I'd like to emphasise in relation to this, that firstly, one starts with OFAC may choose and apply its own definition of property interest subject to deferential judicial review. So then at the bottom of that section, there is the reference to what that means. So we must, and it's in the context of OFAC deriving its powers from the President under the Emergency Powers Act, that we must give effect to OFAC's regulations unless they contradict express statutory language or prove unreasonable. See Chevron. And this is what is known as, I referred to it yesterday, I think, as the Chevron test or the Chevron principle. And then at 12, the court discusses how this comes about, namely, firstly, the OFAC regulations and their definition, then that there was, in effect, an informal adjudication by OFAC on this point. And then that judgment as a contemporaneous application application of OFAC's own regulations receives an even greater degree of deference than the Chevron standard and must prevail unless plainly inconsistent with the regulations. And that's where you then get to the plainly wrong. So if that is a gloss on the starting point of the Administrative Powers Act of arbitrary, capricious, or otherwise in accordance with law, you go through those steps to get to that point, and that is why Mr. Wall quite rightly pointed out the plainly wrong test. So if that has been described as a gloss, but what I'm trying to identify is how you get to there and how the court, the US court, got to the standard which it applies.
Yes?
So the next point, please, is the point that Mr. Wall identified FAQs by OFAC. These are frequently asked questions, and the suggestion being that OFAC wouldn't consider a bank in the issuing bank's position here, Sberbank, to be involved with a transaction so as to engage the captor directive to. You were taken to the FAQ that is behind tab 54 of the supplemental bundle. The point that is made by Mr. Fleming in the joint memorandum is these are FAQs relating to licenses. So they concern activity that would otherwise be caught by the captor directive to sanctions. And one can look at that by going to the FAQ and say behind tab 54 of the supplemental bundle, page 318, that you were taken to electronic page 326. And one can see there that it starts off for transactions authorised under general licenses. This is an example of what would be permissible fund transfer. And then as I say, this is the point made by Mr. Fleming. The reference to his answer to this in the joint memorandum is at supplemental bundle tab 60, page 368, electronic page 376. I won't ask to look that up now, given the time, but I would also invite reference when you do look at it to the preceding page, page 367 at D. My fourth point, please, are the US cases to which you were taken, the Consark, Centrifugal and Semitex cases. Consark, that was a case where OFAC's interpretation of property interests was upheld, and it was the claimant beneficiary under letters of credit that was making the claim that was rejected, that it had property rights in the funds in question. The centrifugal case, as we set out in our skeleton argument, is one of a breach where OFAC was putting forward the proposition that the Iraqi party had a property interest in funds, but it was doing so on the basis of the breach of the underlying contract hence there was discussion of the autonomy principle. It didn't, in that case, make no reference and no analysis of the regulations themselves, because that wasn't the basis upon which, and the definition of property interest, etc., that wasn't the basis upon which it was put by OFAC, who simply referred back to the underlying contract in relation to the letters of credit. And the Semetex case, we say an important distinction is that in that case OFAC was not asserting any property interests that existed on behalf of the Iraqi party. So the court wasn't applying, as it would have done in the Consart case, it wasn't looking at a determination by OFAC against either the Chevron standard or even the higher standard of whether or not its interpretation and application of its own regulations was either plainly inconsistent with them or plainly wrong. It was simply acting as a court in any ordinary civil dispute rather than applying a heightened test. But perhaps most importantly from those two cases, firstly, as Mr. Wall indicates and states in his report, none of them would cause OFAC to alter what he accepts would be its view, particularly in relation to the blocking sanctions that they would apply in this case. And he says so, he deals with this in his report because he says actually what OFAC would do is rely on the very expansive terms of property and property interests that are contained within the Russian regulations. That leads me on to the second point on this, that none of Consart, Centrifugal or Semetex concern the Russian regulations and their more expansive term of property and property, or definition rather, of property and property interests.
Why do the Russian regulations come into this tool?
Because the respondents say, well, those are cases where you can see that the US court would not, or has taken the view that there aren't property interests by the sanctioned party in the property at issue in those cases. But where you have a situation...
Does that only come into your case because you've linked the application in relation to the payment by Sberbank? I mean, sorry, I haven't quite followed why, if all that's being asked is for payment by UniCredit to the claimants, we've got anything to do with Russian regulations or concepts of property.
Because whether or not they would be, those payments in US dollars would be caught by the US sanctions depends upon whether or not there would be any dealing in a property or property interest held by Sberbank. And so that is the basis upon which there is the engagement of those sanctions on those transactions. And so that requires one to look at the definitions in the Russian regulations. And that is why Mr. Wall says that is what OFAC would do. It would rely on the expansive definitions in those regulations. And my point is those are different and more expansive than the more limited definitions in the Iraqi regulations that were the subject of those other cases.
But,
so perhaps, my lord, Mr. Wall, in his report, he deals with this point. So it's behind tab 53 of supplemental bundle. It's page 309. The printed page. At paragraph 63, Mr. Wall explains why he thinks that OFAC wouldn't hold the Semitex case as relevant precedent for its determination of whether or not payments by the confirming bank in US dollars to the beneficiaries would engage the US sanctions under the Russian regulations. And as he says there, that they would assert a broad interpretation of the terms, relying on the expansive definition in these regulations, and then he footnote 13 on page 309, those regulations. Those regulations, which my Lord Justice Mail pointed out yesterday, include obligations. They include, they're very expansive, they include services of any kind. They're more expansive than the regulations that were at issue in the Iraqi cases.
Right.
And following on from that, so those cases deal with a more limited definition of property interest than are at issue here. But also, those cases don't deal with the issue of whether or not a confirming bank payment to beneficiaries would constitute services to the issuing bank, because services are caught by the Russian regulations in the US. As we've set out in our skeleton argument, there are two limbs to the blocking sanctions under the Russian regulations. The first is the provision of services to sanctioned parties. The second is any dealing in property or property interests. Those 30-year-old cases dealing with the Iraqi regulations that my learned friend relies upon deal only with the issue of property and property interest, which is defined in a more limited and narrow sense under those historic regulations than the ones at issue here.
Right. Now, it's very nearly 4:30. How much more have you got to say?
Not very much, my lord. But on the issue of services, the court was taken earlier on to the evidence where the payment by the confirming bank to the beneficiaries is a service to the issuing bank, Sberbank, for which Sberbank pays a fee. So the evidence was both in the July meeting with OFSI and ECJU that was referred to this morning, where the UniCredit officer explained that, and maybe, my lord, if I just give the reference to that, it's tab 13 of supplemental, page 135, electronic page 141, but also in the OFAC application itself, it identifies the fee payments made by Sberbank when the three, in relation to the three celestial letters of credit. So we say in this case, as Mr. Fleming identifies, that one of the reasons why those payments from confirming bank to beneficiaries would be caught under these Russian regulations in the United States is because they provide a service to the issuing bank, and that is prohibited. And that leads on, and under CAPTA, we say, just as a matter of common sense, if you're providing a service to an issuing bank by the payment or by fulfilling the obligation under the letter of credit to pay the beneficiaries, that is a transaction that involves that issuing bank. And as Mr Fleming has identified in his report, that is, in his view, the position that OFAC would take and that would be upheld by the court. The fourth point on the UBAF enforcement decision, the point was made that there was a letter of credit opened by UBAF with a sanctioned entity, but in our submission, and this is why the point that Mr Fleming made, the important bit and why that is would be caught by the sanctions is because there is a US dollar cleared transaction on it, so it's the point of payment on behalf of or under that letter of credit, and that because that's what provides the jurisdictional hook. Actually, we say it's clear from that case that OFAC found that there was a violation because of the payment onwards to the beneficiaries through the US dollar cleared transaction. And the last point, point 5, it was said that as whether or not, when analysing whether reasonable efforts were made to obtain a licence, the court can look to the Semetex case as an example of a simple application. We say that's of no real assistance to the court. It's a case 30 years ago, in circumstances very different from those that face regulators around the world in the commercial fallout following Russia's invasion of Ukraine in February 2022. Those are my points, unless I can assist the court any further, my lord.
Yes, well, thank you very much. Thank you to everybody who has taken part, whether speaking part or not. We will reserve our judgment. In due course, we will provide drafts to you for correction of any typographical or minor factual errors, not for re-argument or anything of that nature. You will all be well aware of the embargo on draft judgments, and you will know that the court would take very seriously any breach of that embargo if that were to happen. We will live in the hope and expectation that in the light of whatever we say, you will be able to agree a draft order for us to approve. But if that proves not to be the case, then we will have any short written submissions and we will deal with any outstanding matters without a further hearing. I think that's all I need to say, so that concludes the hearing. Thank you.